So I am joined today for Hey Legal Exclusive with Thomas Ross, KC. Good morning, Tommy.
Morning.
How are you?
I'm fine, great.
Good. So we're going to have a chat today about the Section 275 of the Criminal Procedure Scotland Act, and an issue that you have certainly been speaking a lot about. So will we start with you just telling us how it is that that's an issue that you're concerned about and what you've been doing recently?
Sure. So I started doing trials in the High Court in the year 2000, and between 2000 and about 2022, probably conducted around 100 rape trials, something like that, and became increasingly concerned that the restriction on questioning, which was being applied by the judges, was having an impact on the fairness of the trials. Obviously became aware of the fact that I was not the only one with these concerns. Most of the talk in the common room when people were complaining or, complaining about their lot in terms of being trial lawyers, probably 90% of those conversations were about questions which were not being allowed in rape trials. And I just became increasingly disillusioned with the whole process. That was the main aspect. There were other aspects, and ultimately I took the decision that I would make it public, that I wasn't doing any more rape cases, and I had the intention of researching the 275 question properly, and at some point speaking about it or writing about it. That process actually took quite a long time because I stopped taking on rape cases, I think in 2022 actually, but obviously I had some. It take about a year to get through the system, as you know. So I took the view that it wouldn't be right to speak about the issue until I was completely free of any cases, and just in case anybody thought I was trying to get some influence on the cases which were to come. So I did that, and actually what triggered the most recent developments is the Royal Faculty of Procurators in Glasgow asked me to do a talk and said I could really talk about any criminal law topic I wanted. And that was the perfect time to do it because I knew I would do the research. And having done the research, something quite extraordinary happened because there were lawyers in attendance at the talk, but there was also principally women from groups who were concerned about miscarriages of justice. And I spoke to them after the lecture, and clearly they are concerned that in the trials that they know of involving their partners and their sons and their nephews, that there were questions which were not allowed to be asked. There was material which was not allowed to be put in the trial. And then I started to get letters from prisoners who say I'm in custody and I wasn't allowed to ask this, and I've got an appeal and no lawyer's prepared to touch the appeal. And generally it's spiralled to a level where it's clear there is substantial public concern that men in Scotland are not getting fair trials in some situations. And the principal concerns are either, one, that the lawyers are not being allowed to ask questions which are relevant. And secondly, a subject which I think is sometimes overlooked, it's restricting the ability of the accused to give evidence in his own trial because, once it's been decided that the issue cannot be raised, not only can the lawyer not question on the issue, but the accused no longer allowed to speak about it. And that creates a slightly unreal situation where the accused is essentially giving evidence to try and, keep his life on track and has been interrupted because the judge has decided that a particular issue is not something that the jury are allowed to hear about. So that's where, that's the journey in a nutshell. And the last couple of months, more and more of my time has been occupied with responding to inquiries from media organisations and members of the public who are concerned about this issue.
Yeah. So I suppose, as you've said there, as lawyers, we have for some time seen the impact of this Section 275 and the restrictions and questioning, and as you say, the gown room, if you walk into a gown room across Scotland that are dealing with sexual offence cases, that inevitably is going to be the topic of conversation and the restrictions placed.
Yeah.
But what you're saying is actually now we're seeing the impact of that, where people have been convicted and families. And I think I've interviewed some of the ladies from gyms, and they say they met because they were sitting in the waiting room at Berlini and sharing stories, and it seemed that their stories were incredibly similar in that in each case they said that evidence hadn't been laid before the jury. But in terms of Section 275, obviously it's a statutory provision, but how has that become the position now? How has it, I suppose, been allowed to? Has there been any opposition to it being implemented over the years to get to the stage it's at?
It's quite an interesting story, because I don't have any doubt that before 1985, some women were very, very badly treated in court by lawyers, sometimes by judges, either directly or by failing to intervene in what was being put, because it wasn't permissible to attack women on grounds of character before 1985. But when the Law Commission looked at the issue in 1983, I think, it was clear that the rules which were there to protect witnesses were simply being ignored, and knowing some of the personnel who were doing those trials back in the 80s, that doesn't surprise me. So I think there was bullying. I think women would have been asked about things which were completely inappropriate. I don't have any doubt that things were bad and intervention was needed. I'm not sure Scotland would have come up with it on their own, but there was developments. The same problems obviously were happening in all the common law countries, including England. And so Scotland had to look at it. And the Law Commission report in 1983 said that there were really three areas of significance in relation to cases of rape, namely evidence to show that the complainer is of bad character or associates with prostitutes, evidence to show that the complainer has had intercourse with men other than the accused, either before or after the rape, and evidence to show the complainer had had intercourse with the accused, either before or after the rape. And as far as I know, nobody in the legal profession challenged any of those propositions. At that stage, anybody could see that it had absolutely no relevance to the case before the jury to ask a woman, well, we're here to try the case of X, but wasn't it the situation that a week ago you had consensual sex with Y? I mean, anybody can see in a minute that is really designed to humiliate the victim and to take the jury off the issue. So there was no resistance to that. And, the first version of the legislation came in 1985 and really outlawed questions of that type. And the procedure was really, really straightforward at that point. There was no need for a written application. The idea which followed the English practice was that everybody would hear the evidence in chief of the complainer, and then if counsel thought some of the questions might transgress the section, then a verbal application was made before cross-examination was embarked on. Incredibly, the way things have gone, the Law Commission didn't think that there was any need for the Crown to make any application under any circumstance on the basis that there would be such good faith on the part of the Crown that they could be trusted not to raise any issues that transgressed the section. So they didn't even need to make the application. The defence made the application before embarking in cross-examination. And the idea was that the prohibition was on sexual questioning or questioning in relation to sexual matters out with the terms of the charge. And I'm unaware of any resistance to that in the legal profession. I don't remember anybody ever complaining about it. However, some of the lobby groups who have become increasingly influential argued that the provision was essentially being ignored and that it wasn't stringent enough. And therefore, in 2002, that section was essentially wiped away, and the Sexual Offences Procedure and Evidence Scotland Act 2002 came into force in November 2002, and it introduced the concept of behaviour, and that's where the problem started, really, because it's very, very easy for us as lawyers to know that you're asking this woman about some sexual conduct. What is behaviour? You know, so many of the cases, you know, if you send somebody who you say has sexually assaulted you, you know, if you're sexually assaulted in 2002 and you send them a Christmas card in 2003, is that behaviour? I didn't know, you know, and so you had the bizarre situation where the lawyers would go in, they'd put in an application and they'd spend 20 minutes arguing the application, and then the judge would say, well, I don't think you needed an application in the first place because I don't think that is behaviour. So that was really the first time when it became problematic. I suppose enforcement of it was a bit sporadic. Sometimes you would get away with asking the questions without any application. But obviously the pressure groups kept an eye on the situation. I've no doubt that women were complaining that things had been asked which shouldn't have been asked. And ultimately, there was greater enforcement of it. And then the next major difficulty, which I think is really the root of all the concerns, was a case which was around about 2013 from memory, where actually it was suggested that the starting point is whether the evidence is relevant. So things then became really complicated, because what the judges actually were saying in CJM in 2013 is you've been getting it wrong all these years, because before we even get to section 274 or 275, the judge should be considering whether the evidence is relevant. And not to put too fine a point on it, it seemed to me in the 10 years that followed, things that if you walked up to the Buchanan Galleries this afternoon and asked 1,000 people whether that issue is relevant to a rape trial, probably 999 would say it was relevant, but routinely the judges in the High Court were refusing permission for the issue to be raised. And it seemed to me there was an entire disjunct between what normal people who sit on juries, let's not forget the people who sit on the juries in the rape trials, who would expect to hear. They would presumably, if they knew these issues were live issues, they would probably think they would have a bearing on their assessment of the credibility, you know, and it's impossible if you haven't been in the trials, and most people have not been in rape trials because, as we know, the evidence of the complainer is done in private. Essentially, it's only the lawyers who are there, so there aren't members of the public watching it. But most of these cases, most of the single victim / complainer cases come down to one person's word against another at the end of the day. And so the assessment of the credibility of a witness is a huge issue in a way that it's not, you know, you can do an entire murder case these days and there's no assessment of credibility of anyone. You know, it's all phone records, cell site, that kind of thing. And the question for the jury at the end is, well, is this enough evidence? We know there's some evidence, there might be evidence enough for suspicion, but is it enough to prove it beyond reasonable doubt? You know, routinely that's the discussion I'm having with juries. But in rape cases, it's so different where you're saying the whole case is witness X. If you don't believe witness X, then the judge will tell you that you can't convict because the case has to be proved beyond reasonable doubt. And you've got all these points which challenge the credibility of witness X, and the court says, well, you're not allowed to raise any of that. You're not allowed, you know. She said to the police that he had intercourse with her 10 years ago and she was pregnant and she had a baby, and we've looked at that and she wasn't pregnant and she didn't have a baby, but you're not allowed to ask her about that because that's not what the case is about. The case is about whether, you know, this happened 4 years after that. Now, That doesn't make any sense to me. And no matter how many case reports I read, I just thought, this isn't right. This isn't right. These guys are not getting a fair trial when things that clearly have an impact on the credibility. And, you know, like most problems, it was incremental. You know, you would hear of a bad example and you would think, well, it can't get any worse than that. And then 2 weeks later, you would hear an even worse example. And then 3 weeks, you would hear something else. And, you know, I couldn't do it any longer. You know, I just couldn't do it. You know, and I remember having a conversation with a wee boy. He was only about 18, very, very immature, as a lot of these kids are. And his dad was there, and his dad was looking, dad was maybe a wee bit younger than me, but age, closer in age, having a conversation with the dad in the way that you couldn't have it with a wee boy because he was so much younger. And the dad was, I was explaining, the dad was looking at me as if to say, what kind of lawyer are you? You know, this clearly, this is my boy. He's going to go to jail. He's going in the sex offenders register. He's never going to get a job. I'm telling you, I want this evidence read, and you're telling me I'm not going to be allowed to read it. That's on you. This is your fault. You know, if you're the kind of lawyer that cannot get this evidence in, then you're clearly not up to it, you know. And I couldn't do it any longer. It was, you know, it's a hard decision. And, you know, I never really thought I would ever say that I wasn't prepared to take on a challenge. But I was just banging my head off a brick wall and getting nowhere, getting upset, getting annoyed about it. And I thought I can do more good by walking away from it and talking about it. I mean, because, you know, the worry is if you make a public statement about anything, there are some cynical people who will say, well, he's just an ambulance chaser. You know, he's talking about this because he knows clients will come flocking to him. And so I'm in the unique position where I'm getting 5 letters a week from the prisons and I'm responding to them saying, I don't do that kind of work. So good luck fighting it.
I mean, you're right when you say, you know, years ago, the pendulum was so far against complainers, and I'm sure some women were treated in a dreadful way by courts. But comments from our colleagues are very much that it seems to have swung too far the other way, and very much I still do these cases, and you do feel that at times you're conducting a defence with one hand tied behind your back. And I think that's a bit the public don't quite understand. If you give examples, you know, an example I can think of is a complainer who had twice previously made false allegations of rape against 2 other, you know, unconnected people, but she'd made them, she'd committed them to a police statement, she'd come back and signed a police statement to say, I lied about that guy raping me.
Yeah.
And that would seem to the man in the street that would be relevant for a jury to hear, because as you say, that's the test is, are they credible, are they reliable? Can we rely on them for a conviction? And yet that was deemed irrelevant to the rape case that I was defending. So it's very difficult for the public to get their heads around. And I think, again, amongst these kind of gown room discussions we have, it's difficult for us lawyers to even follow sometimes the reasoning behind it. And very often what you end up with is the court has ruled in a way that any case that's before a jury, it all kind of starts in the bedroom, or 2 people are in a bed, nobody knows how they've got there. And I often wonder whether that actually encourages speculation from a jury who then think, well, wait a minute, have they been in a relationship for a while? How does he come to be there? So it's it's difficult to explain to people, the general public, how this actually works, and more so, I suppose, to the families of those who are convicted, or the convicted people themselves, as to why they weren't allowed to lead specific evidence that would seem relevant in defence of themselves.
I mean, there's a lot of different issues which have been prohibited, but you touched on the subject of false allegations. I've never understood the logic of that, and when I think of how do you explain it to non-lawyers, if I made a claim for invalidity benefit on the basis that I had a bad back and I submitted the claim in 2022 and I then admitted to you that I just made all that up, that I never had a bad bank. I just wanted to get the benefit, and you reported it to the benefits agency and they stopped my benefit. If 2 years later I went back and made a second claim on the basis that I had a bad back, would it be legitimate for the benefits agency to take account of the fact that I'd previously made a false allegation? You couldn't find one person in Scotland who would say it's illegitimate for the benefits agency to take into account the fact that you previously made a false allegation. Now, that's a couple £100 a week we're talking about. When somebody's life is on the line, they're going to be put on the sex offenders register, sent to prison for 7 or 8 years, difficulties getting contact with their kids, all of that's on the line. And everybody knows, including the prosecutor, that the person making the allegation has previously made false allegations against other people. You know, it's as bad as that everybody knows the situation, and in private the lawyers are having a discussion, which in most cases the starting point is you're not going to be allowed to ask her about that. Yeah. That's the starting point. Yeah. And, you know, things have come so far. I don't remember the last time anybody even had a discussion about it. It's so entrenched that you cannot ask a complainer about false allegations unless there's a conviction. Now, how do you get to the stage where there's a conviction? You know, a senior police officer contacted me and said, basically, they're not allowed to charge victims with making false allegations unless they get the authority of a senior officer. They're not even allowed to charge them, you know, because it's so ingrained in the public consciousness that it's damaging to victims to talk about false allegations. People make false allegations. Yeah. People routinely in Scotland are convicted of making them. And when they make them, they explain through their lawyer why they did it. You know, I was drunk, I was taking drugs at the time, I was in financial difficulty, you know, I'd fallen out with him, he'd gone away with my pal. You know, they give explanations as to why they did it, usually in the spur of the moment. And I'm prepared to accept that they're not common. You know, I don't know, but I've obviously listened to a lot of complainers, and I don't get the impression there are a lot of people just completely fabricating allegations in the way that the woman in Barrow did, you know, when she was making up allegations against people she'd literally never met. You know, I don't think that's widespread. But what I'm concerned about is, you know, people will get themselves into situations and think negatively about it after the event. You know, they'll get themselves involved in some sexual compromising situation with X, and then the next day they think, well, you know, if my partner found out about that, so I'd better tell the story in a different way, you know. That's the sort of change in the history that gets people into a lot of trouble. And once they've given that account, of course, they know if they go back to the police and say, actually, it didn't quite happen that way, it happened a different way, there's a huge amount of confusion on the part of the public as to what happens then. Will I get charged with wasting police time? Will I get charged with false allegations? I don't know. You know. So once you've given the story to the police, there must be huge pressure to stick to the story. Yeah. And our job as defence counsel is to try to show the jury, well, this person cannot be depended on in this particular account. And, you know, it's the investigation that's under. We've also not only have we got to a stage where really no lawyer would even attempt to raise the question of false allegations by the complainer. It's the whole thing is controlled by the Crown on the basis that the discussion about what's admissible really becomes what the Crown are trying to prove at the trial, you know. And I think it should be the whole investigation. So in other words, if somebody, you know, there's various examples in the case law where the victim tells the police something which is palpably false. You know, here's my story, and part of the story is, and they tell the police something that's false. Crown look into it, they discover that it's false, and therefore it's no longer part of the case. So when the trial comes up, that bit is not part of the case. And then the defence are saying, well, I want to ask her about that because she was making the complaint against X and part of her story. And the judges just say, well, that's irrelevant because That's no, it's not irrelevant because we need to decide whether she's a truthful person. And in court, I'll ask her questions and she'll answer the questions, and the jury need to consider whether that's credible. Same thing at the police station. She's given a statement to the police. They're asking her questions. She's answering the questions. And I say, when she was answering those questions, she told lies. Jury surely need to know that. But routinely, they'll just say, well, that's not part of the prosecution case. All that we're here to try is what happened at 6 a.m. when the two of them woke up in bed together, And that is entrenched as well, so bit by bit, the various areas that you were allowed to stray into in 2022, where the jury would say, well, I don't know what they say, but they might say, we've been told by the judge that unless we believe her and we find her to be credible beyond reasonable doubt, we can't convict. So because she told lies to the police on that, how could you regard her as credible? So we can't find it proved. If you don't give them that information, the danger is they've got so, the thing is, the trial's become so focused on 6 o'clock in the morning that they don't have enough material to decide whether the witness is credible. And they just think, well, why would she say that if it wasn't true? Not knowing, which is a perfectly reasonable, if you're a non-lawyer sitting as a juror with a big question, some people might be saying, well, why would she say that if it's not true? Now, the answer might be, that's a reasonable starting point, but we know that when she was asked a question by the cops, she did say something that wasn't true. If you're not getting the chance to put that information before the jury, there's got to be a risk that people are being convicted when they shouldn't be convicted.
Yeah. And there certainly seems, as you say, back to say 2022, you might put an application in thinking, oh, well, I might get that. I know I probably won't get this, but we'll give it a shot. Now it's almost, our colleagues are saying, well, there's no point even trying because the law it seems to have progressed so quickly over the last few years. And it's not to say, I always think we're at a situation where, you cannot ask really anything in defence now that goes to any kind of behaviour or whatever. But it's not to say that if the jury had that information before them that they're automatically going to acquit. It just is to put a true picture before them, that I think is where the frustration comes, and the kind of manipulation, it seems, of evidence that is allowed to go to a jury, and even, as you say, chopping out bits of a police interview where an accused has been asked at the outset for his position, gives that position, but by the time it gets to the trial, and depending on what's on the indictment, he may not be allowed to play that in full to a jury to let them know what he said at the time. So it just that increasing feeling of being unfair, I think has led us all to feeling like that.
I mean, two points occurred to me as you were saying that. Firstly, it must be incredibly frustrating for the complainers when they're trying to tell the story and the lawyers are saying, no, you're not allowed to. I mean, you must have been in a situation many times when the evidence is text messages or Facebook messages or WhatsApp messages, and way before the trial, the lawyers have all gone through those messages and decided what's relevant. And sometimes the answer's left in and the question's taken out, or the other way about. And it must be incredibly frustrating when the complainer is given the document, Crown Production 3. She knows what the conversation has been and she's looking at it and she's been asked about it. And what she wants to say is, no, he'll let you understand this bits have been taken out here. What was actually, and everybody's saying, no, you're not allowed to tell us that. Yeah. You're not allowed to. And she's like, why? I'm trying to, jury are here to try the facts. I'm trying to explain what, and they said, no, we've already decided you're not allowed to talk about that. And I remember one of our colleagues was doing a case, and it was try and keep it as neutral as possible, but it was basically a woman and two men. The woman and the man were boyfriend and girlfriend, and then there was a male friend. They'd all been out drinking. They were quite drunk, went back, and the couple had gone into the bedroom, and then she'd come out and said something to the guy which he was trying to portray as a kind of a flirtatious comment to try and get him into the bedroom. That was basically it. And this had been debated amongst the parties before the trial. So a forum of words had been agreed in terms of the question that the defence counsel was allowed to ask. So he's got it written down, and he gets up and he asks the question, and she says, I think I know what you're getting at. What I said was, no, you're not allowed to. And she said, but he just asked me the question. And she's like, no, you're not. Mm. And she had said something. I think what she was saying was, I did say that, and it does sound sexual or flirtatious, but it was my pal and we were just kind of joking about, I think that's what she was trying to say, but she wasn't even allowed to repeat her own words. These were her words, and she was trying to say, and the defence counsel wasn't being hostile or anything. He was just saying, I need to ask you this, and she was quite happy with it. She was quite happy to explain it, and just wasn't allowed to explain it. And the guy get convicted, and the defence counsel was thinking that just was not a satisfactory experience, because the one point we had was he's sitting in the living room minding his own business, and she's kind of come in and said something along the lines of, he's too drunk, so it's on you, that kind of thing. And we did the whole trial. That was really the key point, and we never got to it. We were never allowed to explore it, and it didn't make any sense, because sometimes there will be humiliating messages, and the only purpose really is to humiliate the victim, and nobody's suggesting that. But it seems when the issue is so central to how they ended up in bed together, that the woman who's absolutely desperate to tell the jury what actually was said is prohibited from doing it. And,
does her a disservice almost, doesn't it?
Because I think there was an article in one of the papers yesterday about this issue, and somebody contributed by saying, well, why should women be asked what dress they were wearing or what shoes they were wearing? And I think there's still a kind of public perception that that's what we're talking about. It's gone so far beyond that. And the other point you made, which was a great point, is the debate tends to focus on the questions that we're allowed to ask, and obviously as lawyers that's our focus. But the decisions that are made on that affect the way in which the accused can give evidence. And I don't think the public see that, So in the Supreme Court case, there are two cases which were argued in the Supreme Court in October, still no judgment. And it was basically two men who were convicted of rape, and the complaint was that the trial was not compliant with Article 6 of the European Convention on Human Rights, because they were not allowed to, in one case, they were not allowed to raise certain material. In the other case, the complaint was actually that the lawyer had not applied to put the material in, but the appeal court had refused his appeal on the basis that even if the lawyer had applied, it would never have been allowed anyway. But it's a really good example, real-life example of how the ability of the accused to give evidence is affected by this, because it was a situation, I think, reading between the lines, they were all workmates. They had gone out after work and they'd gone to 4 pubs, one after the other, and the female was seen to beckon her workmate into a disabled toilet in one of the pubs, and they had sex in the toilet, and then they'd get a taxi from the pub to his house, and again there was some kind of sexual contact in the taxi, and then they went back to his house and there was further sexual contact there. So she woke up the following morning and in his bed claimed that she couldn't really remember very much about it, claimed that she would never have consented to any sort of sexual contact because she didn't fancy him. That was the kind of story. So clearly when he heard that, he thought, well, one, I'm going to be able to show the CCTV from the pub where she was like sucking his thumb and beckoning him into the toilet and all that kind of stuff. So he was charged with a sexual assault, possibly a rape in the toilet. the Crown saw the way the wind was blowing in the argument and pulled that charge. So that was no longer going to, so the pub's conduct was no longer going to be part of the trial unless the defence applied. Defence applied to read the CCTV, refused. Yeah. So the jury never heard anything about that.
Because it didn't relate to
what had happened in the house.
Yeah.
But worse than that, the accused position can be crystallised at the interview stage, as you know. So a lot of people give evidence in court, but some people give their account to the police, and then the lawyer can say, well, you heard the interview, you've got nothing to add to that. So he was interviewed by the police, and when the woman's account was put to the man at interview, he said something like, well, it was a continuation. It started in the pub and it continued in the taxi, and then it continued at the flat. So the matter having been debated, it was agreed, or not agreed, it was declared by the court that it wouldn't be possible for the jury to know anything about the pub or even to know anything about what happened in the taxi. So the case was restricted. So the question became, well, what do we do with his interview? Mm-hmm. Because at his interview, he's talking about the pub and he's talking about the taxi. So what are we going to do with it? Now, they can take words out of a paragraph. They can't put words in. They can take words out. So this account which he gave, which was basically, it was the same incident. It was a sexual episode, and all that it was consensual, it was continuing, and all that changed really was the place. So it started in the pub, it continued in the taxi, and it continued in the flat. All that was allowed to be put before the jury from that explanation was, we have sex. We have sex. Now, it's not grammatical. It doesn't make any sense. No. You know, it doesn't explain that it was consensual. In a way, it's all bad news for the accused, really. So they've taken something which, if you listen to it, you might think, well, he says it starts in the pub, and here's the CCTV from the pub, you know, where she's sucking his thumb and, you know, beckoning him into the disabled toilet and all that. They don't get any of that. What they get is, we have sex. All they've really heard is what happens at the flat, and they're thinking, well, what does that mean? He's not even saying it's consensual or anything. He's accepting it. So, you know, now, nobody is ever going to be able to explain to me how that's fair. No. How's that fair? The guy's in giving evidence, you know, and didn't give evidence. I'm not sure what bearing what had happened in the 275 had in that decision. But, you know, instead of the jury seeing his interview where they're able to assess, you know, his demeanour and his credibility as a result and all of that, it's cut down to a point where they just get a 3-word ungrammatical sentence, and his whole future has been determined on the basis of that. That doesn't seem fair to me. No.
Just one point, as you're talking as well, that we're talking about witnesses being credible, and I've been pulled up in a case for saying to a jury or addressing the court and saying that she is not a credible witness, whereas I think it's in the jury manual or the bench book, which says no, it's the evidence has to be credible and reliable. I'm not sure how you distinguish the two, but any comment on that, Tommy?
Listen, I don't understand it any longer. You know, I really don't understand it. And I was actually encouraged when I watched the stream of the UK Supreme Court hearing. You know, I might be talking out of turn. It seemed to me that the English judges didn't understand it either, you know, at points. You know, it had been explained that the reason, you know, the real difficult turn, as I said, came in 2013, where they started introducing this relevance test. We're talking about people's lives, and they're saying we're not prepared to waste time on collateral issues. You know, the whole idea, if we're dealing with something that happens when the victim was 25, we're not going back to the fact that she made a false allegation about somebody stealing her pencil when she was in primary one, you know. So that would be a waste of the court time. It'd be a waste of the jury's time. we get that.
Yeah.
You know, in the Supreme Court, when that concept of relevancy and collateral, you know, evidence can be relevant, but it can still be inadmissible because it's collateral. You know, when you go down that rabbit hole and explain it by saying, well, trials can't be limitless, you know, we need to focus on the issue. And the English judge comes in and says, hang on a minute. You've explained that concept to me. It's all about economic use of court time. It's all about not wasting time investigating issues which really don't have to do with it. In this case, the important evidence was the CCTV for the pub. You as the prosecutor, you showed some of the CCTV for the pub because you wanted to prove that the woman was drunk. Right. And another part of your case was things which he said at interview, essentially where he was accepting intercourse. And the jury knew about that as well. So they were getting to see some of the CCTV and they were getting to hear part of the interview. We're not talking about going back to when he was in primary one stealing a pencil. What you're saying is the CCTV was evidence in the case. You took the bits that didn't suit you out. The interview at the police station was part of the case. You took out the guy's explanation. So don't come in here and tell us that it's all about economic use of court time. It's not about economic use of court time. And even if it was, it would be a disgrace. You know, what is an extra day in court when you're talking about a young guy getting sent to prison for 6 or 7 years, you know?
Plus on the sex offenders register,
Exactly.
which arguably is equally as or perhaps
It's worse, possibly.
worse than a jail type
Because they have
sentence.
to let you out of jail
Yeah,
eventually.
exactly.
Whereas they don't need to take you off the register,
Yeah.
you know?
So where do you see this all ending up, Tommy? How we're exacerbated at times as it is in terms of what we can lead. Where is it going, and why is it going in this direction? What is, do you think, the reason behind it all? I understand that, you know, the ways that complainers were treated had to be changed, but why is it now gone to this level, do you think?
It's really difficult to be optimistic about it. I mean, I'm slightly more. I used to say, if you speak to members of the public, they won't believe it. But nobody had spoken to members of the public. You know, members of the public are involved as mothers or sisters or partners of men who are charged with it. They get it. The wider public don't get it, you know, because they don't have a particular interest in the criminal justice system. I'm encouraged by the fact that some of the things I've spoken about in social media and have attracted some public interest. And so that is a positive. It's a positive that it's been confirmed to me that my suspicion is right. You know, that when you explain what is happening, members of the public cannot believe it. They can't believe that if that was my boy and been charged with rape, he would not be allowed to lead evidence that this woman has made 4 previous false allegations against people. Public don't get it. So it's got to be encouraging that the public are starting to get it. The problem is the public don't sit in trials as judges, or they don't sit in the appeal court. To be fair to our judges, the direction of travel of the appeal court has very much been in favour of restricting the ability to challenge the evidence, and they're bound by that. So even if you had a judge who listened to all the things we say about it and thought, you're right, it has gone too far, if that trial judge allowed the questioning of the type that we've been talking about, the Crown can appeal it, and then the appeal court can say, no, the trial judge was wrong. So we're bringing in the prohibition. One of the things which seemed to astonish the English judges, and it is procedural, so I'm maybe getting slightly off topic, is the idea you can have the application granted. And, you know, if we go to the preliminary hearing, you argue it, you win the argument, the trial is then a year later, and you come back a year later with all the material ready to be put, and the trial judge says, I've read this. I want to reopen it. I want to discuss it again. And then in the morning of the trial, the judge says, well, I don't agree that does, you know, comply with the terms of section, so I'm disallowing it. And your entire preparation for the case is out the window, you know. So I cannot be optimistic that things are going to change. I'm just kind of glad that I've got it into the public domain and people generally seem to agree with me.
Yeah. Tommy, thank you so much for talking to us today.